Today is another episode of Tommy Talks Legal. As you all know, I am Tomilola Daniel. Kindly subscribe to my YouTube channel and click on the like button as we go on this insightful journey. In the previous episodes, we spoke about the tenancy law of Lagos State, how it affects the landlord and the tenant. Today is going to be a continuing episode for the previous one. We are going to be discussing 7 things a landlord and a tenant should be aware of during the period of their tenancy or at the commencement of their tenancy. Number 1, no tenants should coerce the landlord to receive in excess of their annual rental value for a property. Neither should a landlord instigate or insist that a prospective tenant should pay in excess of the annual rental value. According to the Lagos State Tenancy Law, this is an aberration. It is an offence for you to receive or pay in excess of your annual rental value. Upon conviction, this offence is liable to a fine of 100,000 naira or 3 months imprisonment. 2, upon payment of rent, the tenant is entitled to the issuance of a receipt. Where the landlord fails to issue a tenancy receipt to a tenant, the landlord has committed an offence that is liable upon conviction to a fine of 100,000 naira or to a 3 months imprisonment. Number 3, there are certain apartments that you pay for service charges. Now, if you are in an apartment that you are required or that you are paying for service charge, you are entitled to be issued a separate receipt showing the amount or the value of the service charge you are paying for on a yearly basis. Beyond the issuance of the service charge receipt, the tenant is also entitled to an analysis of how the service charge is being expended on a half-yearly basis. Number 4, where a tenant has fulfilled all monetary obligations towards the rental of a premises, the tenant is entitled to quiet and peaceable enjoyment. Quiet and peaceable enjoyment translates to exclusivity of the demised premises. However, exclusivity of the demised premises does not prevent or stop the landlord or the landlord's agents or privies from having access to the demised premises for the purpose of inspection. Quiet and peaceable enjoyment also translates to privacy of the demised premises. Quiet and peaceable enjoyment also translates to the tenant not having any form of unnecessary disturbance on his demised premises. Number 5, where a tenant carries on a structural damage with the written consent of his or her landlord, the tenant is entitled to compensation for such repairs to the structural damage. But if the tenant does not have the consent of the landlord to effect such repairs, the tenant may not be entitled to any form of compensation. Number 6, where a tenant has duly notified the landlord of a damage to an exterior part of the demised premises or a common place of usage on the demised premises, and the landlord fails to imminently effect repairs to such exterior damages, the tenant is entitled or has the right to ask or approach to ask the landlord or approach the court for a compensation. Number 7, a tenant is entitled to a common place or a common service for the use of the demised premises. If this session has been insightful enough, or you have learnt one or two things from this session of mine, kindly click on the like button and subscribe to my YouTube channel. Thank you.